Good morning, good afternoon, greetings to all, wherever you are. I welcome you to our panel on artificial intelligence and the spread of hate speech and propaganda, challenges and possibilities in the use of AI and its legislative regulation. This is a long, exciting title on this extremely important subject. I would like you to invite viewers on LinkedIn, Twitter, Facebook, and YouTube to type your questions in the comment section throughout the panel discussion. I would like to start by thanking our partner, the Montreal Institute for Genocide and Human Rights Studies, MIGS, for organizing this important and timely forum and for inviting the Global Action Against Mass Atrocity Crimes, GAAMAC, to feature its community's expertise on artificial intelligence and human rights under a legislative perspective. I am very pleased to moderate this panel in my capacity of chair of GAAMAC. GAAMAC is a political state-led initiative composed of states and civil society organizations that engages and supports states everywhere to protect their populations from atrocity crimes by seeking to address root causes within their societies and to promote prevention at the national level as an upstream and permanent endeavor. Rather than a mere reaction, indeed, GAAMAC promotes globally the establishment and strengthening of national permanent atrocity prevention architectures. Today's panel is supported by GAAMAC and co-organized by our partners, the Platform for Peace and Humanity, the Sentinel Project, and Parliamentarians for Global Action. In recent years, advances in artificial intelligence technology have sped up significantly, and artificial intelligence is rapidly taking on a central role in our day-to-day lives. While AI is making the world a smarter, faster place, it is also accompanied by emerging threats against human rights standards and other disruptive effects. AI-enabled disinformation, the resulting spread of hate speech and propaganda, as well as key norm issues and missing policy remedies, are some of the challenges associated with emerging technologies. Our distinguished panelists will provide expert discussion on the legal issues and initiatives that are needed to tackle AI-enabled disinformation and spread of hate speech. I want to extend a warm welcome to our panelists. Let me introduce them. We will start with Mr. Rastislav Šutek, Executive Director of the Platform for Peace and Humanity. While one of our newest partners, we are grateful of their key contributions to our community so far. Then we will hear from Ms. Raashi Saxena, Global Project Coordinator of the Sentinel Project, which is another valuable partner of GAAMAC. And last but not least, we will have the honor to hear from Lord Clement-Jones, member of the Parliament of the United Kingdom. Lord Clement-Jones joins us in his capacity as Member of Parliament and was introduced to us by one of our oldest partners, Parliamentarians for Global Action. Now, let's start our exciting discussion. We will start with Rastislav Šutek. Now, Rastislav, your organization has been analyzing key challenges and opportunities related to the legal regulation of the prohibition of propaganda for war. Now, can you please elaborate briefly on the misuse by artificial intelligence in spreading propaganda and how AI can be used to target the specific online contents? And how can criminal enforcement of the prohibition of propaganda for war work by using artificial intelligence? These are indeed very timely questions. So thank you, Rastislav, for giving us your thoughts on these questions.
Good morning or good afternoon. Thank you for the introduction and thank you for the invitation to speak about such an important topic indeed. When it comes to propaganda for war, I think in Central Europe, here we have seen some kind of a revival of the need to deal with this harmful internet content, especially after the February Russian invasion in Ukraine. Certain online comments of public figures approving or justifying the invasion have received attention, and criminal investigations have been opened into these expressions, and several online portals promoting the Russian invasion have been blocked by the national regulating agencies. I think this was a timely step, but globally, this is not something extraordinary. Google is regularly publishing its 6 months data compilation of requests made by the states to remove specific content from the search engine, YouTube, etc. And for instance, national security ground for content removal closely related to the prohibition of propaganda for war has been invoked in the past 6 months by many states, including the US, Russia, Poland, Turkey, the United Kingdom, etc. And this shows that this harmful content is not only relevant in terms of scrutiny under the freedom of expression, but also states see such content as problematic for their national security. Of course, addressing and countering hate speech and propaganda for war is a multi-layered endeavor, which includes tackling root causes in drivers, preventing it from translating into violence and illegal use of force, and also includes dealing with wider consequences for the society. However, the difficulties of addressing and legislating about propaganda for war, but also hate speech, begin first with the definition and the delicate balancing between the freedom of expression and any limitations to that, which are always sensitive in Western societies. The prohibition of propaganda for war is primarily conceived of as a special obligation to take preventive measures to enforce the right to life, and also to give effect to the prohibition of the threat or use of force in international relations. The legal regulation is very rare indeed. It's only Article 20 of the ICCPR, International Covenant on Civil and Political Rights, but we also see some references to the prohibition of propaganda for war in American Convention, especially in Article 13, paragraph 5. The only difference between these provisions is that the American Convention, based on the proposal of the American delegation, included the qualifier that the lawless violence needs to be reasonably expected as a result of such a statement, which is not explicitly included in the ICCPR, which is just very briefly prohibiting the propaganda for war. The European Convention on Human Rights is also silent on the prohibition for propaganda for war, but we can already deduce some analytical explanations from the vast case law on the freedom of expression that such a statement would not be acceptable in the Council of Europe jurisdictions of the domestic states. The present developments, on the other hand, the regulations that we see increasing all around the world signal actually quite a radical change. Especially in Europe, where many states have been vocal opponents of the prohibition of propaganda for war. When the ICCPR has been adopted, we know that from the drafting history, also from the reservations and declarations that have been submitted. But we also see a revival in domestic jurisdictions and desire to regulate big tech companies. While this is mainly done in the hate speech area, I believe that a lot of these good practices can be directly translated to the propaganda for war statements. So, for instance, in May 2016, the European Commission agreed with Facebook, Microsoft, Twitter, and YouTube on a code of conduct on countering illegal hate speech online. And there are regular reports from social media companies which are published into monitoring rounds, informing the public how the flagged content, the harmful content, was actually dealt with. But the EU is also trying to step up the responsibility regime with the latest attempts to minimize harmful content with the new Digital Services Act, also known as DSA. While the proposed act provides that the definition of illegal content should be interpreted broadly, covering not only hate speech, it remains to be seen whether any explicit action will result regarding propaganda for war. When it comes to national legislation, we have also seen quite important improvements. For instance, the German Network Enforcement Act, which was presented in 2017, requires social media platforms to implement a transparent procedure to moderate illegal content, including hate speech. Again, there is no explicit reference to propaganda for war. Another obligation is to remove this content, which has been identified as illegal within 24 hours, and regularly report to the domestic regulatory authorities. The law was heavily criticized as pushing platforms into the role of some kind of privatized censorship agencies for the decisions that they have to make. Um, and it was suggested that courts are better suitable as a forum where such claims should be dealt. But on the other hand, there have been claims that such time limitations and fines would lead these online platforms to over removal of the content when risking high penalties. In 2020, the law was partly revised to require social media platforms to forward the identified illegal content directly to the Federal Criminal Police Office. And this is actually a good sample how artificial intelligence moderation can directly cooperate with the national criminal agencies. When it comes to artificial intelligence more specifically, we also see some efforts to regulate the use of AI. But again, these regulations are general, and practical implications for human rights and propaganda for war remains to be seen. For instance, the Council of Europe is working on an international instrument regulating the use of AI, which would also include connection with freedom of expression. And also the EU is preparing its AI Act, which is using the model based on the risk-based approach to artificial intelligence. Um, it should be noted that artificial intelligence is already used in content moderation on social media platforms, and there is no suggestion indicating that future regulations would change that. Twitter, YouTube, Facebook, to name a few, they are presently using a combination of AI moderation based on machine detection and human moderators kept in the loop, and it can be expected that AI will eventually fully replace human moderators. Now, there are arguments against and in favor of content moderation, generally apply to any harmful content, be it hate speech, but also propaganda for war. Some arguments against AI content moderation have long been discussed in terms of evidence of international crimes. This could result in AI content moderation blocking evidence of the commission of the crime of aggression, preparation for that. Let's take an example of a leaked footage of a meeting, governmental meeting, where politicians call for military action. The other argument appearing is that artificial intelligence is incapable of fully understanding the contextual background of these statements. So, for instance, let's take the initially innocent letter Z before the Russian invasion and after the invasion. So this has been such an issue for several brands all around the world. For instance, Samsung has stopped using the letter Z in some online advertisements of its foldable phones in order to be avoided as being flagged as harmful content. On this occasion, it is also argued that AI cannot fully understand coded language present in propaganda for war, including some militaristic language. However, a practical application of artificial intelligence already suggests the contrary. The US company called Primer has developed an artificial intelligence which has been supplied lately to the Ukrainian military. The AI was able to provide surveillance of the Russian military based on the intelligence that AI has obtained from the intercepted Russian communication. Another argument against AI removing propaganda for war may arise that the AI is incapable of filtering statements advocating for illegal use of force. But this is not an issue inherently present in the technology, but rather the lack of clarity of the legal norms involved in the use of force and freedom of expression regulation. So this was some overview of challenges I see in the AI content moderation of propaganda for war on the internet. But I'm sure there's plenty more to discuss in the Q&A, and I will be happy to answer any questions. Thank you.
Thank you very much, Rastislav, for this very illuminating first overview of some of the challenges. I think this is extremely helpful, and indeed we will come back for sure to certain aspects in the Q&A part. So now we go to our second speaker, and I would go now to Raashi from the Sentinel project. The Sentinel project in 2013 launched HateBase, which is the world's largest structured repository of multilingual, usage-based hate speech available in 98 languages across 178 countries. It is an attempt to create a repository of words and phrases that researchers can use to detect the early stages of genocide and remains in active development. So, Raashi, can you elaborate further on the findings of the HateBase and reflecting on the need for human rights to be actively integrated into how online spaces are governed? Can you share good practices and lessons learned on this? The floor is yours, Raashi.
Thanks, Sylvia. I just wanted to check, can you all hear me?
Yes, very well.
Okay, great. So hi everyone, I hope everyone's doing well. So our logic and reasoning behind starting HateBase was that we wanted to get a greater understanding of how the online world influences the offline world. We don't necessarily have that understanding, and also understand how online coordination activities kind of result in a better understanding of the overall dynamics in this case, the high friction environments that we usually work in, given that we work on mass atrocity prevention. So a lot of the environments that we do work in don't necessarily have reliable piece of information. So we come up with the definition of hate-based, or rather hate speech online, as any expression, regardless of offensiveness, that broadly categorizes a specific group of people based on malignant, qualitative, and subjective attributes. And these attributes can pertain to religion, nationality, ethnicity, class, and disability, and sexuality. So this is our definition. We don't necessarily consider hate speech as localized insults. And our idea was to build an active monitoring database of online hate speech, which is global in scope, but it can also be regionally focused. And we also, since we also work with communities directly, and specifically the ones that are in harm's way. We also kind of look at a more crowdsourced vocabulary and offensiveness approach when it comes to monitoring online. And for us, this would be, we're looking at hate speech as an early warning indicator, in conjunction with other aspects that you find which are normally used. For example, misinformation and hate speech is always used interchangeably. And also wanted to say that the reason hate speech and misinformation and a lot of these phenomena aren't necessarily new. It's just that the coordination and the manifestation of these aspects are different when online. But for example, you look at the previous genocides, you look at Nazi Germany or the Armenian genocide, the rate of dissemination had probably required a lot of infrastructures and stakeholders coming in together. People had to have more financial resources, but now the rate of dissemination online is much faster, thanks to social media, and it's also very difficult to identify the source of hate speech or misinformation. And now we're essentially more of a monitoring tool. We don't police speech, but we're kind of trying to understand what's really out there. So we're monitoring publicly available conversations. So you have Twitter, Facebook, and all the training data sets that we've received from different organizations that are working on hate speech. So we work with academics, activists, individuals, linguists, organizations from across the world who want to use our data set for their purposes of research. And we've also worked with a lot of universities in the past. So we've also realized that there are a lot of challenges, technical challenges, when it comes to, or rather with the usage of AI, because we do incorporate an element of it in our work. So one is that there's not a strong understanding of the relation between offline and the online world, and one is that there's also strong linguistic coverage is a huge challenge, because what there are different dialects. What might seem offensive in one particular context might not be offensive in another context. So, for example, a terminology in the US in English is very different from a terminology that's used contextually in the UK. I'm based out of India. We have different dialects of Hindi. So that's one aspect that is a huge challenge when it comes to the training of AI data sets. And also, of course, the sheer volume of data that is now available, given that we have a lot more people who've gone online because of the pandemic and so many other factors, is that AI seems to be a more, we would say, humane option to be able to monitor hate speech, because human moderators and their capabilities might be limited. Because if you can imagine the mental health implications that a lot of human moderators have by looking at heinous content for 12, 15 hours a day. And we've also seen that human moderators aren't necessarily paid and compensated well. So in that aspect, there might be a more accuracy with when it comes to monitoring with AI, but we also have our side of human moderators who, of course, check everything. And we're also not looking at, when we look at understanding hate speech, we do believe that online communities have a right and legal responsibility to moderate user activity and to ensure fair treatment of users. But we also think that ostracization of there's also a blurred line, because we don't have a universal definition of hate speech, online hate speech per se. So a lot of ostracization of unpopular speech in the developing world is seen as hate speech or labeled as hate speech. So many of them have been incredibly broad, and they're also used domestically to suppress opposition of speeches. We specifically look at it from a content and linguistic aspect of it. So we don't have the ability to do that. And we also think that allowing discriminatory content to proliferate silences marginalized voices, which is a form of censorship. So what is the solution that we found when it comes to be able to allow or rather help us have a clinical understanding of hate speech? We introduced something called the Citizen Linguist Lab, which anyone can contribute to across the world, and it's basically to have a better social and cultural understanding on the ground. The platform at the moment is going open source, but earlier and of course it can be anyone from across the world is allowed to contribute to it effectively, and so you can be based in Latin America or South America or even in Asia. So you don't have to necessarily be a linguistic expert if you understand that particular language. And of course, we're also looking at increasing the number of languages that are already available to be able to, contribute and understand it. So we categorize it differently into our systems pertaining to gender, sexual orientation, disability, and class. And we also have something called an offensiveness score, so that even the ones who don't necessarily want to input a terminology can also rate the existing terms that are available. Currently, we have around 4,000 terms, which are spread across 178 countries. We also have sightings, which is the frequency of these terms. So we have close to 950,000 different sightings. And go back to the offensiveness score aspect. This is also for us to be able to understand the social climate of the regions that we are dealing with, because we realize that hate speech is very contextual. It depends on the two people who are talking to each other. It can be between two different tribes, or between a minority group and a majority group. So it's very, very contextual and specific. And for the offensiveness score also helps us to understand that there's some terminology which was accepted perhaps 40 years ago, which now seems offensive. And our primary users and beneficiaries are always people on the ground, so that the average citizens can have more understanding and agency to be able to tackle these issues. And of course, 90% of our use cases are free, and we've now completely gone open source so that we can also understand from other people across the board on what we can do to be able to improve our systems. And then we also look at for us to be kind of looking back, and the takeaways, what we could say is that we are always on the side of education and counter messaging rather than censorship, because we've realized that censorship might not be the most effective way, and it can kind of reinforce the beliefs of a lot of people who are in the field of propagating hateful content. And of course, all of the things that we do, it's also very independent. It's done very independently and transparently, because we understand that a lot of terms we do get are very sensitive in nature. So a lot of the information is, of course, personally anonymized. And perhaps that's about it. And I'm, of course, happy to answer any questions that anyone might have. Thank you.
Thank you. Thank you very much, Raashi, for these very interesting reflections on this important subject. I will now move to our next and last speaker for this round. And before I turn to Lord Clement-Jones, I would like to remind participants to please send your questions via the chat feature. So as soon as we end this first round, we can address these questions. So Lord Clement-Jones, as a member of Parliament, can you elaborate on the role of members of parliaments in prevention? In particular, the role of member of parliaments in adopting human-centric artificial intelligence laws to prevent and address the repression of dissent and vulnerable individuals and groups. And can you provide us also some examples of risk assessment and policy recommendations in this regard? Lord Clement-Jones, the floor is yours.
Thank you very much indeed, Sylvia. And I am going to concentrate today pretty closely on social media regulation and the issues that arise from hate speech on social media. I've worked quite closely with the Council of Europe, with the OECD, on AI regulation, the broader aspects of making sure that AI is fit for purpose and is risk-based and basically is our servant, not our master. But the really important area at the moment, which I want to focus on, is, if you like, the role of algorithms, AI, in social media. And I think all parliamentarians, regulators need to approach this in a fairly humble fashion, because we've had some problems, I think, in catching up with the technology over the years. I mean, we need to remember that the last time in the UK, and what I'm going to say is mainly related to what we're doing in the UK to combat things like hate speech and misinformation and disinformation. But the last time we actually revised our criminal law in the area of hate communications was when only 12.6% of our population had a computer. That was back in 1988. And the internet was not even invented until 1992. So the revision that we're undergoing at the moment is long overdue. And we need to remember that Facebook came in only a year after our last Communications Act, which was 2003. So Facebook has been around in some form or other since about 2004. Twitter followed in 2006. So the regulators are struggling to catch up, particularly in the online area, I would say. And the real dilemma that they have is precisely what we've heard identified by Rastislav, which is this problem about perhaps over regulating or over compensating by social media platforms the dangers to free speech. And I think we have to be very cognizant of this really important aspect, that we need to hold the ring between freedom of expression and making sure that hate speech, misinformation, threats to democracy, if you like, are regulated as well. And in that whole area, I would also include the right to anonymity as well. And I think the fact that under the European Human Rights Convention we have Article 10 is a really important aspect that we need to hold to, and make sure that when we do legislate or regulate, that we're making very sure that we conform with that. And make sure that freedom of expression is guaranteed, despite our desire to make sure that the worst forms of hate speech are eliminated. And our Law Commission, which is a group of senior lawyers, including many judges, has been grappling with this whole issue of communications offences and hate crime for the last 3 or 4 years. And now they've come up with new proposals, and those are in parallel with proposals from our government, which have taken 3 or 4 years themselves to come up with in the online safety area. And so this is coming together, and this year is going to be a crucial one for UK regulation and legislation. And I think what has been really interesting is the growing realization that you cannot treat online very differently from offline for the purposes of liability. And it's really important to make sure that the social media platforms do have and do own, take ownership of issues like hate speech and risk assessment for the kind of communications that appear on their own platforms. And I think that understanding and that policy objective now to make offline and online equivalent is a really important aspect. So it was in that light that our Law Commission have now set out a new offence that they want to see brought in of sending knowingly false, persistent or threatening communications, which are likely to cause harm to a likely audience. And the harm that they're talking about is psychological harm. It amounts to serious distress. There must be an intent to cause it, but no proof of actual harm is needed. So they've set out this really quite clear offence that they want to see in the communications area. And then they've got another offence that they want to see broadened. We already had hate speech law, but they want to see that broadened into an offence of stirring up hatred on the basis of certain protected characteristics. Now, there is some debate about whether misogyny should be included in that new offence, but those two offences are going to be crucial if we're going to regulate our online platforms in the future. And I sat on a committee which scrutinized a draft online safety bill, which has now been introduced into Parliament. And we said it was absolutely crucial that these two new offences should be brought in. And I'm pleased to say that that seems to be the case, because in order to satisfy the requirements of Article 10 and freedom of expression, you really have to be saying you can't have criminal behavior when you communicate. Otherwise, you're opening the door to government control of free speech. You're opening the door to censorship, which Raashi mentioned as being highly undesirable, and I would entirely agree with that. So that's, I think, the background to where we are in the UK. And it's, of course, online hate speech is widely recognised as a societal problem. We're in the process of trying to make sure that we define it in terms, as I say, of likely harm to a likely audience, and you need intent and so on. I think the area which is really difficult is the area of misinformation and disinformation, which has a societal impact. It's very straightforward to identify individual impact or the member of a likely audience and so on. What is really difficult is to try and regulate where there's an impact on democracy. And, for instance, our Intelligence and Security Committee of Parliament in the UK identified that there had been Russian misinformation, disinformation by bot accounts, inauthentic accounts, as they're called by the social media platforms, during our general election and during our Brexit referendum. Now, we don't really know what the extent of that was. There were allegations, of course, during the original Trump election in the States of the same kind of interference. And so that, I think, is the thorniest issue that we have to deal with. And we haven't come yet with a solution, except to say that if under our new legislation, we have safety by design and we have risk assessment as compulsory aspects of regulation of the social media platforms, the very design of a platform should try and make sure that misinformation and disinformation is not amplified. Now, that's still fraught with problems because of the definitional issues, but at least if there's some systemic risk approach to design by the platforms, then that whole area of amplification is something that we think will at least be moderated. I don't think we can say that it's going to be eliminated, but at least we're going to moderate that. And there are all kinds of tools, if you like, which are really important. And identifying hateful content on social media may be difficult, but the platforms certainly should have the ability to do that. And under our new piece of legislation, our online safety bill, there's going to be compulsory risk assessment in accordance with a risk profile drawn up by the regulator. There's going to be a safety by design duty. There's going to be the ability of the regulator to audit the algorithms which amplify and distribute content. And there are going to be very strong transparency requirements. And that, I think, is one of the really important aspects that we have to expect. So, for instance, it will be important that platforms say what are their safety by design features, what are their terms and conditions, the proportion of users who are children, proportion of anonymous users, proportion of content breaching terms and conditions which have been removed, and so on. So there's going to be quite a long list of transparency requirements that are required as part of the annual reports drawn up by the platforms. And this is going to be, I think, a very important element of the regulatory regime. And of course, the growing reliance on algorithms and algorithmic systems, there are dangers in terms of personal data. We know the business model of the social media platforms relies on people getting rather extreme content, and that is, I'm not really underplaying that, because having eyeballs, having clicks is an essential part of the social media business model, and we've got to make sure that that is not just something that perpetuates itself, and we do try and understand that. On the other hand, and we come to the freedom of expression point, it's really important that we don't have a situation where genuine journalistic content, genuine content in the public interest is not allowed on social media platforms. And if you like, they compensate for the regulation that's imposed on them. And we were very keen to make sure that there was proper protection for journalistic content. That appears in our draft legislation, in our legislation. But I'm sorry to say that I don't think we've dealt with it in quite a proper way, because if you're a journalist, you're protected. But if, for instance, you're a blogger and you're blogging, in the public interest, you might be whistleblowing or doing whatever, it might be possible still for a social media platform to take down your content and for you not to have any redress. In terms of the pluralism of and the diversity of media, it's obviously extremely important that social media just doesn't simply dominate the news space. And so, of course, there is a role for competition authorities alongside our regulation of the online space through our online safety bill. We also hope to see some new competition legislation with a new digital markets unit, which will have the job of making sure that we do maintain, if you like, competition pluralism in the journalistic space. Now, I think one of the trickiest areas is the whole area.
Sorry, thank you very much, Lord Clement-Jones. I'm sorry for interrupting, but your time is up. But in addition to being up, you already have a question. So maybe I would like to ask this question for you, since you are now with taking the floor. This is already a question about this online safety bill. Is there a concern that when we punish platforms for failing to moderate content, that we encourage them to be more or too liberal with their moderation?
Yes, well, it depends what you mean by liberal. And there is a concern, because liberal in that context means too restrictive, actually, i.e. moderate too much. And I agree. And this is really important. And this is why we criticized the previous version of the online safety bill. And we said that to have legal but harmful content, which was going to be regulated, created big problems, because the Secretary of State, the ministers, would have the ability to say what legal but harmful content was not allowed on social media platforms. Well, that's been removed now, and it's going to be specified in greater detail, and it's going to be subject to parliamentary oversight. So I'm very pleased, actually, that has been changed, but it's still not quite good enough. We still think that the government, the Secretary of State, has too much power over the decision about what kind of content is going to be allowed on social media. So that's why we stuck very, very closely to the illegal content, including the new offences. And we weren't very keen on just having a sort of sweep up of legal but harmful, which at the moment nobody quite knows what the government have in mind. So I absolutely agree with the questioner.
Thank you very much for this, and you, like the other speakers, have really also emphasized the importance of freedom of expression, and but also the need to define further what we mean by harmful content. What is harmful, and what is the limit to becoming illegal or criminal? Now, there is a question addressed also for Raashi at this point from the speakers that I would like to ask to Raashi. Raashi, going back to the issue of maintaining the balance between timely tackling of online the speech and freedom of speech, what role for artificial intelligence then? I don't know if you understand this question that comes from the speakers. Yes.
Yeah. Artificial intelligence, perhaps. I mean, maybe looking at it from social media, a lot of my fellow panelists also mentioned that artificial intelligence, or some aspect of it, is used by social media companies, and it's used perhaps at the first level, because, as I've mentioned earlier, there we do need automation for the sheer volume of information that is out there, and there is different moderation techniques that are required for different platforms. For example, Twitter is a lot more open. You don't necessarily need an account to be able to view content, whereas Facebook is a lot more closed. So those are the different challenges that are there, but an automation element is necessary to be able to format and to be able to identify the different lexicons that we have. So yes, as I said, we're looking at it from a research element purposes. So we're essentially looking at the frequency of the usage of these particular terms. Perhaps these are coordination activities that are going to result in a particular group picking up arms against a particular community, or for us to be able to verify an ongoing rumor in a particular community is true or false. I hope I've answered your question, but I'm happy to.
Thank you very much. And I see there is a question for Rastislav. From Rastislav, building on your remarks, what would be good examples of effective enforcement of the prohibition of propaganda for war to prevent the outbreak of a conflict?
No, thank you for the question. That's actually a tricky question, because in the broader context, we're really struggling with preventive mechanisms in international law. And I think there is a place that is often neglected, and there's where the position of the propaganda for war and the enforcement of the prohibition plays a major role. there are no analytical data to really support how effective is this prohibition, if at all it is applied in any way. There's also only a handful of monographies, a handful of articles on the topic of prohibition of propaganda for war, unlike hate speech and misinformation. And in terms of artificial intelligence implementation, even less. I was going all over the internet to find how tech companies have approached sharing the letter Z all over the internet. For instance, a few Instagrammers have been spreading it in various content and promoting the letter Z, and at the same time promoting the invasion this way. And Instagram, while it was flagged as an illegal content, has not removed it, has not even considered it as a harmful content. So without these data, we cannot really predict any effective enforcement of this provision. This closely relates to machine learning. If we want to design artificial intelligence capable of tracking propaganda for war over the internet, this requires correctly labeled samples to start getting good at prediction and gradually progressing this task. And for that purpose, there should be a certain amount of predefined content flagged as propaganda for war. If there are any successful examples, we know them from the case law, which is also very or extremely rare. The jurisprudence of the European Court of Human Rights, which is indicative that this prohibition of propaganda for war would not be supported under the freedom of expression, gives us only a handful of indications in its case law. So we have examples from the Turkish cases of Kurdish separatism calling for separatist claims from Turkey, poems, online content, which has been removed, and European Court of Human Rights has correctly noted that such a content is not protected by the freedom of expression. This would be perhaps one example how Turkey perhaps correctly approached such an issue. It was invoked under the National Unity Clause under the Prevention of Terrorism Act of Turkey. So this is, I think, a good practice. I hope that answers the question.
Thank you very much. And I see there is also now a question for Lord Clement-Jones. And let me read the question for everybody. We have seen that members of parliament themselves are increasingly using discriminatory and violent language, especially during elections, through online platforms to attack other peers and collectives who oppose their convictions. What can legislators do to ensure that, as representatives of the citizens, they refrain from using such language, and what mechanisms are there available to hold them accountable?
Well, that's a really interesting question, because the GPA, the PGA has got a set of standards which they ask parliamentarians to sign up to. I mean, and I think those standards are a very, very good template. I mean, you can argue whether you can have a global standard given cultural differences. I mean, you know, the Australian Parliament, for instance, is their language is a lot more brutal in some ways than the UK Parliament, but you know, it's still within the bounds of polite, or what one might regard as being reasonable discourse. Perhaps polite is the wrong word. I don't think any discourse in our parliament is particularly, or the Australian Parliament is particularly polite. But I do think that sets a very, very useful set of standards. But it is, I think, at the end of the day, a matter of law. And I don't think that you can expect parliamentarians necessarily to hold themselves back in circumstances where they're on a public platform and they make a perfectly a legal statement. If they're inciting violence or hatred or discrimination or whatever it may be, then of course they will be caught and they should be prosecuted. I think we should hold parliamentarians to a higher standard, but I don't necessarily think that we should regard it as a terrible thing if as long as they maintain legality. I think what we should expect the electorate to do is to judge them on their actions and their words, and so that if particular parliamentarians are excessive in the way that they express themselves, then the electorate has to make up their own minds. But I'm very conscious about the freedom of expression aspects. There are many aspects of the PGA code which I think are great, and actually it relates back to the Turkey point that was being made earlier. Calling in aid national security excuses, I think sometimes can be false and misleading, and that is part of the PGA code, and I think it's a very, very good point, actually.
Thank you very much. We are reaching the end of this really fantastic panel on AI. And so we would have some questions for all panelists. This is a question to all panelists that comes from the audience. What is your intake from Elon Musk's recent acquisition of Twitter and his absolutist approach to free speech? Apparently, he said that free speech is that which matches the law. However, we all know that there are authoritarian countries where this may lead to the persecution of individuals and marginalized groups. So the floor is yours. Who wants to start?
Shall I kick off?
Yes.
Elon Musk is one of the most unpredictable people in the world. So his opinions can turn on a sixpence. And now he runs Twitter, and it's got to make its way commercially as well. He's paid $44 billion for it. It's got to work. And I note that in the past, he's talked about being against the way that bots operate, which I think is very positive. But I think he's just got to recognize that in many countries in the world, and with the EU's DSA, with the UK's online safety bill, Twitter will be regulated. And I don't think he's going to be able to shy away from that. So I hope that he's not really an absolutist. I think he may well change his mind. But if he isn't, and he thinks that hate speech has a place on Twitter, then he's going to find the regulators come after him with some very big fines.
Thank you very much. Any other speakers want to also address this issue?
I can second that and then follow up with a few comments. So partially, I agree with the position on the differences when it comes to matching how free speech will be regulated on Twitter and whether it matches the law. We know for sure that how freedom of expression is regulated in the US and how it is protected under the First Amendment is completely different from how European jurisdictions approach hate speech and propaganda for war as well. Propaganda for war is mainly regulated in criminal codes of Eastern European states, whereas in Western European states, many of these countries have lodged reservations to this provision. So Twitter and many other social media platforms, they operate across multiple jurisdictions, and based on this simple division of how law operates in various geographical regions, we see that it's not simply easy to provide clear-cut answers to how it should be regulated. And as for Twitter and its future, I completely agree that at the moment it's unpredictable. In Europe, a lot is counted on the DSA. There are strong fees provided. Although on the other hand, it's a question how it will financially impact big tech giants, because this is only leeway how the European Union presently can approach big tech companies.
Thank you very much. Thank you. Thank you. I don't know if Raashi, you want to add a few words on this or any other matter. We are really getting into the end of our panel.
Sure. No, what I would say is that as Rastislav also mentioned, that there are different jurisdictions where Twitter will be allowed to abide by the human rights and privacy and security aspects of Twitter. So that's not going to go away. And I also don't think that we're not going to have no content moderation at all. It might be a platform that perhaps is more, I would say, politically neutral compared to how Twitter was operating earlier. But I would say that if he really wants to fix Twitter, he should put the power in our hands so that the users can choose our own independent third-party moderators to be able to filter our individual Twitter experiences.
Thank you. Thank you very much. And now we really, there is another question for Raashi, but very quickly because we really need to close now. And this question says that given the way social media algorithms work by picking up and amplifying incendiary content, what can be said about the liability of social media platforms in situations such as Myanmar?
I'm happy to answer that by email because I'm going to take a while to answer that, but I can do that if that's
okay. Thank you. If you can answer this very difficult question very briefly, I would appreciate it.
No, you would have to abide by this is a very complicated question, but there are, with the work that we've done in content moderation, you would need to internally downplay some aspects of it, and it would of course require a more, I would say, verification procedure. But yeah, social media companies would abide by their particular jurisdictions. Unfortunately, that is something that they would in the situation with Myanmar. So yeah, it is a complicated terrain, and I'm unsure if they would be able to. Yeah, it is when the perpetrator is the currently elected government, it is a bit tricky.
Thank you. Thank you very much. This has been a great conversation. I really thank the speakers and the audience for their questions, and it's been extremely useful. I would like to repeat some of the very good formulations that you have made, including this important statement by Lord Clement-Jones saying that, well, we need to think how we make artificial intelligence fit to purpose, to be our server and not a master. And that brings us back to what are we talking about when we talk about removal of content or harmful content. And indeed, clear definitions would also help artificial intelligence and human moderation to help us to remove what is indeed harmful without affecting freedom of speech. Although we have also heard, and Raashi was very emphatic on this, but I think you all have shared this, that it is very difficult to define something that it's also very contextual and specific, and it would depend very much also what is a specific country or region, because the context indeed may influence what is acceptable or not in different societies. But I think you have all mentioned about the need of regulation. Again, you said we have to catch up with technology, and technology, although hate speech is not new, of course, we have seen this in the past, in past genocides, but indeed new technologies and artificial intelligence bring new dimensions that were not contemplated in our existing regulations. And we see that there are regulation efforts in many regions of the world and in countries, and in many countries. So this is important, although we are also recognizing more broadly that offline and online hate speech and harmful discourse needs to be treated equally. You have not developed this further. It could be said, it could be used, maybe could be the subject of the next panel on this, and next discussion is that we have talked a lot about regulations and sanctions, but maybe not enough about countermeasuring and education as probably a better remedy than simply looking at this from a criminal or a legal aspect. So, but this will be for a next discussion. We really need to close now. I thank again our very distinguished panelists, and I also want to thank the audience and the organizers of this event. I thank you very much.